All right, I reckon.
Yeah, I reckon so too. And all this rain.
All right, see if we're live, Mayor.
Yeah.
Good.
All right, we'll call this special meeting to order. It's 10 o'clock, so first item on the agenda is approval of modification to alcohol ordinance and set hearing for alcohol suspension. So I'll turn it to Russell.
Mayor, we had a request from a local businessman who said they were gonna be out of town, and requested an earlier hearing date. Come to find out, they were requesting a hearing date prior to March 18th, which we could not have done, with regards to due process and a 15-day notice. Called him, he said, well, April 18th will work, let's do it that day. April 18th is on a Sunday. So April the 16th, would be the potential date if council is still interested in making, accommodations for a hearing. That would put dates for April 16th, April 21st, and April the 23rd. We can split them up however you want. If you just want to do the one on April 16th and the balance between the 21st and 23rd, we can do that, or however you see fit.
How many is it?
14.
Probably like 5, 5, and 4, 4, maybe sooner when you do 4 than 5 and 5, maybe.
The only thing that I would interject is that the attorney that I've talked to that is likely going to be the one presenting the cases, she is not available on a Wednesday. She's available on Fridays. So those would work better for her.
We could set one that she's representing on those 2 Fridays, and then the other one's on that Wednesday.
So how many is she?
No, this would be
Oh.
her presenting the cases to city council for the city, like for the police department.
So you want to
So she's
split them
gonna
on
need
the
to be-
16th and the 23rd, 2 Fridays.
7 and 7.
7 and 7.
Okay.
When now? What dates?
Friday, April the 16th, and Friday, April the 23rd.
And you say this is the individual that's representing the city?
Well, she would be presenting the case for the violation. There needs to be somebody presenting the case for the violation. I can't do that and represent the city council. It would be a conflict of interest if I were to present those
Kind of similar to
cases.
the ethics.
Yeah,
thing.
if I were to present the cases, then I could, if you had any questions, I couldn't answer.
So I guess, wouldn't that be in the DA's office?
They won't do it because it's not criminal.
Yep, we made that request.
Well, who does non-criminal cases, who presents those now? If it's a non, if it's something, I guess that would be brought up in, I guess would a traffic violation be the same?
Traffic violation is a criminal offense.
And that's according to our ordinance, that someone has to present the case?
Our ordinance isn't specific, but somebody's gotta present it. There's gotta be evidence put before city council and mayor for you to determine whether or not, the burden has been met on that side, and then if the, violator or licensee wants to present their case, they get to present their case.
So, and we had offered the chief of police and I could do the presentation. It just depends on if you want an attorney to do it or not.
So I guess we have to pay for this attorney.
Yes.
You would, and
Urban.
we ask them, and they do handle the tickets or citations that we write for properties that are not within compliance.
I guess that's what I was trying to figure out with the example of a non-criminal type situation, what have we done in the past? And if that's been the case,
And
would
then-
it fall in line with that?
The only non-criminal issue that we've presented that would result in any type of potential penalty since I've been here was the ethics complaint, in which case we had attorneys, just depends on what you feel comfortable with.
Right, but it wasn't the city bringing those cases, that was different. Right.
When is the last time this has happened in the city? Do you remember?
I don't remember it
You
happening.
don't? You don't remember the process?
I don't know if we've had one that appealed and all that stuff.
Like this.
Like this.
Had one as well?
Appealed and went through, I don't think we've,
What would you suggest, Dan?
I know that there's an attorney on the other side of 3 of these. And that was my concern. If there's objections to evidence or testimony, you may need some guidance. Whoever's handling the presentation of the violations needs to understand the procedure on that. That was the only reason. And I've talked to other city attorneys and asked them, you know, how they had handled these, since we've never had this procedure before. And they handled them similarly. Some of the ordinances for the other cities do allow the attorney for the city to present the cases, but this being the first time, you may have questions, maybe not. I'll handle them whichever way you want me to, and do whatever position you want me to take.
I see it being a conflict for you, since you do represent the city council, and serve in both capacities.
And you know, it is a due process procedure, and I've talked to Mr. Thompson about, you know, a court reporter being here, so that if anybody wanted to question what happened, you know, we've got to cover the bases. So.
We'll go through this process this time and we'll know, because I really think we are getting a little bit too much into it, but we'll see after this time.
Russell, what about the attorney that was one of the people that applied, the attorney from over in Forsyth area?
We could reach out to him, we have not.
Because I think he represents several cities, so he's familiar with it. And he might have some knowledge of how it's done.
Our ordinances just aren't specific at all. They were written a long time ago, and there's nothing specific in there. So, and that's what some other attorneys have ran into when they were trying to do this procedure, is that their ordinances were not specific as to procedure. And so to err on the side of caution is to do it just like you would in the courtroom for this. Because
So-
it is a due process.
So the citations that are, say, issued by Bobby, are those criminal or non-criminal?
Those should be non-criminal.
So how are those handled?
In municipal court, the DA's office handles all that. But when we asked them, when Mr. Thompson called about that, they said because it was civil, that they would not do it.
But would you consider those being civil?
I would.
I guess I'm having trouble, and I'm just thinking out loud and how do you not make the connection
And
there?
I've not talked to them directly.
On code enforcement, there's a civil process and a criminal process. You can actually cite them and penalize them under the general provision statute, which would be a criminal. But then there's a civil remedy for some of the nuisance abatement, which requires liens and the sort.
One of the things I wonder is, are there gonna be, you know, if we rewrite ordinances and do this, could there be the possibility that there will be other things over the next several years? And if so, should we again possibly reach out to somebody like, you know, I still remember that attorney from Forsyth who had represented a number of cities. Maybe that we're protected with DN having a conflict of interest, but he knows, you know, he represents a number of cities and would have at least the experience.
I'm just looking at it from a cost thing too. We're already paying, you know, or sharing in the cost. I assume, I don't know what, I can't remember what our arrangement is, but DA's office when they hear, city type cases.
And I'm not sure that that would fall under that contract. That's gonna be another issue.
Like Ms. Reeves said, I hope we learn from this one, and figure it out, because it seems to be extremely convoluted.
If it weren't a due process issue, it wouldn't be as necessary to cover the basis, I suppose. But would it be in a due process?
Oh, yeah, if you got to,
You got to.
absolutely. But it's just who's gonna do what and when and how is, I guess, more so what I was, in the future, we can have some arrangements made of who's gonna hear it, how, and representing who, and all those good things.
Russell, you and Deanne want to think about it and then make a recommendation?
Sure. You know, I'm not familiar with all of the intricacies procedurally with regards to due process hearings. You know, my approach was gonna be more to treat it as an administrative hearing. Council presides with attorney's advice. The police department and myself would present evidence. They could cross-examine, they could provide testimony, and at that point, council would deliberate. I don't see the city going back and forth a whole bunch after we've, introduced what we have, but I guess there could be a situation that arose where it could.
And that's, I mean, if you want to handle it that way, that's fine. We had talked about that, and we talked about the fact that, maybe it needed to be handled by an attorney, but it's totally up to city council as to how you want to handle it and who you want to present it.
Yeah, I see the importance of not being tripped up on some technicality when we're trying to provide due process, so certainly don't want that to happen.
That's something we need to have an experienced attorney represent us as far as in this thing. We've got to have a third mind out there to understand what process is. Due process, if we violate some of this due process, it costs us more in the long run and lawsuits and all for not providing for the proper procedure.
I agree with that.
Have you spoken with GMA on how they handle situations like this?
I have not. They're across the board.
Okay.
A lot of alcohol hearings are not even before the mayor and council, administrative staff hearing, so.
That's kind of what y'all did.
Right.
But like I said, we'll learn after this time.
Yeah,
We just,
absolutely.
we digging too much into it, but we'll learn after this time.
My recommendation would be that we, like I said, through the city attorney and the city manager, we look at surrounding cities, how they handle this type of situation, and then, we look at a pool of local attorneys and inquire and see who'd be willing to handle this type of situation, so we can set a precedent in the future how to handle an administrative hearing of this nature.
I guess it'd probably conflict out in a small town like this, wouldn't it? So-
That's what I have done over the last couple of weeks. I've contacted different ones. They all have conflicts. The one that I talked to is outside of our circuit. She doesn't know anybody here as far as business owners. So that was why I talked to her, because she was outside the circuit and not familiar with any of these companies. So, with us having 14, it's hard to find somebody that doesn't have a conflict. If it were one, it might be easier. And we did go that route, or at least tried to go that route to see if there was somebody local that we could use.
So.
All these are just suggestions, the decision's up to you.
So really 3 issues. I guess the first matter would be authorization to acquire legal representation for the presentation of the cases. The second matter would be to add a hearing date of the 16th, which would make both hearing dates the 16th and the 23rd. And the third matter being ordinance modification specific to the penalty provision of the current ordinance. There's 6-70 subsection A. The current ordinance on the city's book calls for a 90-day suspension of alcohol license on first offense of an act that violates the chapter. Second offense requires a permanent revocation of the license. Ms. Deanne has drafted an ordinance modification if council so chooses to head that route. If there are feelings that the current ordinance as drafted is too stringent in the requirement of a 90-day suspension for first offense and revocation for second offense, we have proposed a modification which provides for, and you have a copy of the ordinance that has been handed out, and you can read it, but ultimately it modifies the penalty schedule as follows. For the first violation would be 6-month probation and a suspension of a license not to exceed 30 days. Second violation would be 1 year probation with a suspension of a license not to exceed 60 days. And the third violation would be if it occurred within the probation period, would call for revocation. And those are the considerations for council. If you like the ordinance, we can leave it. If you want to modify it, this was kind of a best guess feel on some of the other ordinances that we had reviewed for your consideration.
Mr. Thompson, what is it you explained to me about the monetary fee?
We reviewed that. Some of them do have monetary fines. Some of them have what they call reinstitution penalties. My recommendation would be at this time to forego a financial piece of the penalty, contingent and assuming that somewhere in the next couple of months we're going to bring you a totally redrafted alcohol ordinance, and we'll have more clarity on the legal provision of having a punitive damage or either reinstitution fee for that license at the time we look at the alcohol ordinance in its entirety.
Are you considering making this new ordinance retroactive?
No,
Okay.
I mean, I don't think you can do that, can you?
No,
You're talking about the one that we'll present in a month or two, is that what you're talking
no,
about?
as I understand the law, you cannot make it retroactive.
So the question with regards to this modification, it wouldn't be retroactive to the point that the violation or the act that triggers a hearing and a penalty is still in play. However, the hearing has not taken place, nor has a decision been made on the effect of the violation. So the penalty provision wouldn't necessarily be retroactive since we would adopt it prior to the hearing. Is that right? I think you may have some issue if the penalty provision were more strict than originally written. However, this gives council broader discretion and lessens the overall severity of the potential decision of the council outside of the fact that this does call for a probationary period. It's part of the penalty where the other did not.
So this would be in effect going forward, so it would be in effect when you have the hearings.
It will be.
It would be.
Yes.
I personally thought 90 days was a long time. I guess since this hasn't happened, I guess in the city of Thomaston for some time, I guess I think the suspension days here are fitting for it is we, trying to do since it has never been done before. That's hard to believe. The city has never gone through and gone through the convenience stores and looked for, selling the bottles. That is really, but I guess if it hasn't been done, it hasn't been done. So I guess this will be a learning experience for us. But I think the suspension outlined in this new ordinance, I think that's appropriate. But 90 days was a long time for the first time.
In my interpretation of the ordinance as drafted, it would give the council discretion, all the way from no punishment, all the way up to 30-day suspension for first violation.
And Mr.
So-
Heath, I'm sorry, I thought about the idea of, well, what about a fine on top of that?
Yeah, but that's
But
what
I think that
you
if you do a 30-day suspension, and that's a
We
pretty.
got a built-in fine.
It's got a built-in fine to it, so I'm okay with that. And I noticed that again, if by chance they, don't have a further violation and you go 2 years, then you're back to step one again. Right, Russell? Yeah.
Ms. Thompson, maybe I misunderstood something you said, but did you say it could be from 0 up to 30 days?
Yeah, because as it's written, is the suspension of the license not to exceed 30 days. So 30 and back.
Okay, so I guess we'll get into it, because I can't, how is it you could say 15 days for this person, and then maybe 30 days for this person, but that is it our intent to look at it like that?
It depends if, depending upon the evidence presented and the defense presented, where there are underlying or extenuating circumstances that may lead you to believe one versus the other. Like, say I'm speeding and I'm just speeding. Well, it's the fine. Well, I'm speeding because, my daughter's in the car and I'm rushing her to a hospital. Everything it's written to take into consideration case-by-case specifics.
But in each
Our only caution would be to treat equal violations with equal penalty.
Right.
And that would be your discretion to
Right.
ensure that you treat everybody equally under the same.
But all
circumstances.
in these 14 cases, they're all guilty, are they not? They were all caught selling alcohol to a minor.
Well, the case has not been adjudicated. Our position is gonna be that, based on the evidence that we're gonna present, we think there was a violation under the current ordinance. Without prejudging the cases prior to the hearing, administratively, we feel like we can make a strong case and point to a violation. However, the accused not being present, we want to reserve that.
Were they issued tickets for selling to a minor?
Yes. Not the license holder.
The clerk or whoever
Yes,
it
ma'am.
is that sold it,
Yes, ma'am.
right?
I guess that could be one and the same, could it not?
Could be.
Potentially.
Yeah.
Right.
So we need some motions to
So we've got authorization.
hire somebody.
Authorization to obtain legal representation for the presentation of the cases, to set the hearing dates as April 16th and April 23rd. And if there's any consideration for the ordinance presented that would modify 670 subsection A.
Do we need 3 separate motions, or
It-
probably at least 2, and then if you're gonna do the ordinance, I'd probably do that one by itself, but
Well, so what we're gonna do, 3 days? Understand the attorney, you're saying that the attorney was the one that was gonna represent us, she can't do it, or he or she can't do it on Wednesday?
Correct.
Okay.
So on the 16th and the 23rd.
Right, if we went with her, she's only available on Fridays,
Oh, okay.
but it,
So it's only Fridays, not Wednesday?
I believe she handles juvenile court cases, and I think she said she was in juvenile court Monday, Wednesdays of each week, but Fridays, she is completely available. She told me. I'll have to check with her about these specific dates.
weekday, Sunday and
Part of
Friday.
it, we're changing code 678, and we're talking about hiring an attorney, and what was the third part?
Set the dates for the 16th and the 23rd.
I'll put that in the form of a motion.
Second.
Have a motion and a second. Any further discussion on those? Hearing none, call for a vote.
Is this for all three or just the first two?
First two,
Okay.
just for the dates and to hire somebody. Any more questions? Then call for a vote.
Councilman Greatham,
All right.
Councilman Middlebrooks,
Yes.
Councilman Reed,
Yes.
Councilman Tucker,
Yes.
Councilman Mahee.
Yes.
Now, the discussion about the ordinance. Is this something you want to change now, look at later?
I'm in favor of changing it now. I did feel like, I mean, I want us to be serious about this, but I did feel like that first shot out of the box was maybe more severe than maybe we should. And
But they are provided with that ordinance when they get their license, so they know the punishment. It wasn't like they didn't know what was gonna happen if they sold, correct? I see both sides of that.
I think it's so.
But no going in, I think we should leave it as it is. If they knew going in.
What's that, Mr. Middlebrooks?
I say if they knew going in, I think we should leave it as it is. Violation.
Then you when they sign the contract, that's permanent.
so as it is, first violation's up to 90.
It's this shall be, right?
Yes.
Shall be.
That's where we're getting into the not to exceed something. Previously, it's always been shall. It's kind of ain't no wiggle room. It's just shall be.
And the second violation would be revocation.
But I guess if after all that stuff and we pass something, their second offense would be
Right.
what the new one would if you went to change it.
Right.
Any thoughts? Everybody else? Ryan, got any thoughts?
Russell, any thoughts?
We'll enforce the ordinances council so chooses to adopt.
Good answer.
Dan, I guess one thing that comes to my mind is direct financial benefit to one or more of the licensee holders. I guess I'm unsure of how I need to wade into this in that respect.
How I would weigh into it?
How I would.
How you would weigh into
I
it?
probably need to abstain from any type of vote, but get your opinion on as to that.
If you feel like you have a basis for abstaining and you don't feel comfortable weighing in on, you're talking about a particular.
I mean, because obviously this would
individual?
have a direct financial impact potentially on the licensee holders.
You're talking about on each one, on all of them that you.
Now, well, it's either one or all, I mean, there's some relationship to some, and I don't, for privacy, I don't really want to go into who that is. But
I
it's- it's a-
understand.
Yeah,
So I was trying to get
Yeah.
clarification on your question, if it would be you abstaining from all of them or portion of them?
well, I'm talking about as we have a broad vote on amending the ordinance, that could be perceived as, I mean, I guess it would have to be some broad vote, this is not just a one or two of
It is
the
a broad
offense,
vote.
right? So,
It's not specific to those
Right.
individuals.
Yeah.
So I think you would be appropriate, it would be appropriate for you to vote on whether or not to change it.
but it affects said licensee holder.
I understand. I don't know that there's a prohibition.
I think it'd be up to you.
It's-
I
it's
mean, if
really
you feel
up-
like it might be, I think it'd be your right to say, I abstain. But, I mean,
Yeah, it's really your call on that and how you feel.
Okay.
It's your right to vote if you want to.
How would you feel, Doug? Would that be the same case with you though?
Yeah, it could be, yeah.
I mean, I may or not, or you may not, or Ms. Keitha may not, but somebody who's listening now could, you know, voice their opinion and say, well, if you have that type of relationship with this person, could it directly impact, this decision directly impact them financially?
See, I could see
That's a,
if there's nothing out there, it wouldn't.
Right.
But seeing that this could impact some hearing stuff, then it could.
Well, so that brings up the next question, whether to vote on this. The next question is if you're sitting
and that was gonna be my next
sitting
question.
in judgment of somebody who's your customer, and you're gonna render an economic impact, a pretty severe economic impact on him, could you be influenced on how you're gonna vote?
And I think that's why other cities and stuff allow it
Yeah,
to be
that's,
the city
especially in
manager.
smaller towns where this is a,
city manager or city clerk or something, some other one form that's not, wouldn't have these perceived violations.
The way that I've seen other cities do it is not necessarily, city manager does the same, has the same procedure that we do. He decides that there's a violation, sends out the notice. And then if they want a hearing, it has to be a different process. It's not it doesn't go before the city clerk or the city manager. It goes before either an administrative officer or, you know, most of them honestly go before mayor and city council. That's what I've seen. Most of them do. I don't know how often they're using that part of their ordinances, but a lot of them are set up so that the due process portion of hearing goes before city council and mayor. But I do understand your conflict. If we didn't have these pending, you wouldn't have that position or be put in that potential position.
I mean, I guess, as far as the hearing goes, I don't know, I guess I could excuse myself, but then you would know who that, I guess it really doesn't matter. A lot of it's public record anyway.
But then I could see you going, if Don was your customer, you wouldn't, I'm gonna not see that case, but Jeff wasn't your customer. Well, if you hit Jeff with a severe
It's gonna
penalty,
hit him.
it's gonna eventually, it may help him that if he didn't have the same kind of penalty.
Yeah.
So it's still, I think you would, if you set out of one, you'd have to set out of all
And
of
that's
them.
where I was gonna say, I think I would,
I agree, because the one who got punished could argue that you're putting him at a disadvantage to your customers, so you acted inconsistently in conflict, trying to help the customer.
I think we got some cleaning up to do after all this stuff to fix some stuff, but.
I think we need to study this a little further, and table it at this point in time.
You making a motion to
I'm
table
making a
this?
motion, we table this until we have time to study and review this ordinance and the impact it will have on present and future cases.
We have a motion to table, there's a second,
Well,
or,
can I ask a question? So if we table it, then we may possibly be putting off
We would effectively be putting off the hearings because we've got to give them at least 15 days. The 16th is coming up pretty quick.
Does the penalty provision have to be, I guess it would have to be established prior to the hearing notices going out, is that
Well,
right?
Part of the letters that we sent out to them initially had the provision of our ordinance that said it was a 90-day suspension. So I think it would be fair if you're going to change it to let them know the change before they come to a hearing. I don't think it's fair for them to get here and then change.
but if you're tabling it to just future thing, not according to this case or these cases,
Well,
would you have to push the hearing back, because you would just go with what you got
Right.
now, wouldn't
Well,
you?
the current cases are under the current ordinance. That's what they signed that permit for. They understood the penalties for the violations of the permit and license. They will understand that. So my question was before, is this retroactive? And you said no, but now you're saying that yes, that this would be retroactive because they have not been to an administrative hearing yet. Well, that is not what they signed up for when they signed up for a licensing permit. They signed up for the ordinance that was in place at that time. They understood the punishment at that time. So, my question is, What are we voting on?
If this is amended before you render a decision, then this would be the procedure, the penalty schedule. If you don't do anything, it would remain the 90 days. But because a decision hasn't been made, this would be in effect at the time the decision was made.
So I guess
But again, it's.
the motion to table would just be to table this issue to a later time, not.
Just to a later time. Give us time to study this ordinance, make sure we understand what we're voting on.
I mean, to me, a time would be when you set the new alcohol ordinances up. This would kind of fall into that. To me, that looked like a good time to do it. I see why we're looking at it now, because there's stuff on the table, but if there was no stuff on the table, you'd probably be doing this while we did a whole new alcohol ordinances. and
You're
stuff.
right. We probably wouldn't be looking at it right now, and I think that there was some question about the ordinance as it's written now, and the fact that it was implemented in 2001 by different city council, and whether we wanted to look at additional provisions for penalty structure, and so that's why we're even here today. But if city council it's not of an opinion to even consider that at this point, it's totally up to city council to do that.
So is that your motion to table this to future?
At this time.
At this time, okay.
So let me just ask, is the only thing that we've got to, Don, you say that we don't know what we're voting on. I think we do know what we're voting on. I think is not the question that's bubbled up here, whether Ryan and I would have a conflict of interest to be a part of the city council that's hearing, and whether it would, isn't that just the issue? We do know what we're voting on. Am I wrong about that? The only thing that's bubbled up here is the question of conflict of interest.
Well, I think what maybe the penalty schedule, the potential revised penalty schedule, about amending that prior to said hearing. Because we already voted previously to change the date, so they're gonna be heard early, but now it's just the matter on the table, so to speak, is the penalty schedule
9 days.
potentially being revised.
So I guess you got a motion on the table to table this,
The revision.
to table the revision or update to this ordinance at this time. Is there a second? There's no second to the table? There's no second. Motion to table is
Fails.
yeah. So now you want to look at this now. Now you're looking at the issue, if we vote on this, is whether now your conflict of interest, I think, comes into play. If there's a
I
motion
think
to
the
go.
conflict would be anything to do with the motion that was just made, as well as any future motion as it relates to the penalty schedule.
I make a motion that we go with the ordinance that's before us now, looking at the, being 30 days for the first offense, 60 for the second, and so forth.
So you're voting to change the ordinance
But
right
to
now.
use- Right, to use
What is it?
what's been presented to us this morning, yeah.
She gonna wanna, she make a motion to go with this ordinance that is in place right here.
Okay.
Make
The
this
new
change.
ordinance.
So, have a motion to change the ordinance to reflect the new one presented before you. Do I have a second?
I'll second it.
Have a motion and a second. Any discussion? Hearing none, call for a vote.
Councilman Greathouse,
No,
Councilman Middlebrook,
Yes.
Councilman Reeves,
Yes.
Councilman Tucker,
Same.
Councilman Head.
Abstain.
Aaron, and you may want to verify with Deanne, but I believe a motion takes 3 affirmative votes to pass.
True.
That's true, so in that case, it fails and present ordinance remains in effect at this time.
When is it we intend to look at the ordinance as far as making revisions? The one we have now?
Deanne, the only thing that, can we have it by second meeting in April?
Should be able to. We have looked at that extensively. It was one of the ordinances that Joel was working on and finalized before he finished out his consultation period with us. And Mr. Thompson and I have gone over it pretty extensively.
I'd like a work session with the council prior to formal meeting on, because it is pretty comprehensive.
yeah.
Definitely gonna have to have some different provisions in there based on this. So it would be helpful to do for working session.
So it look like if we can get it presented to us in mid-April, maybe toward the end of April, 1st of May, work session.
Do abstentions acquiesce to the majority?
I'll have to look at that. Hold on, need to make sure.
Because if they do, it would pass, correct?
Let's look at
Do abstentions do it?
I believe in Robert's rules that abstentions acquiesce to the majority.
It's almost like a
Yeah,
present
that's the
vote,
question.
like a present vote. It's not like if they wasn't here.
Could it also be perceived as a 2-2?
It's a procedural.
Let me look, let me see if I can find anything. It's not expected.
And how does that work with a conflict vote?
Apologize. I'm not certain about the answer to that question.
You also have to look what the definition of majority is, if the majority counts people abstain. Do we need a recession?
I think we call for a brief recess, have a motion to recess to allow time to search this issue and come back.
I make a motion to recess.
Now, a motion, do I hear a second?
Second.
All right. We'll go into a brief recess, or call for a vote.
Councilman Greathouse,
All right,
Councilman Middlebrook,
Yes.
Councilman Reeves,
Yes.
Councilman Tucker,
Yes.
Councilman Head.
Yes. The only thing I have to pause it is executive session, where it says we're in executive session. I don't know how to kill it and bring it back on, so we just need to go to another room, let it roll, and come back in.
It probably would be best, or if you stay in here, just know you're on TV. Have Ryan sing to the camera or something.
They don't want that.
Then you wouldn't have anybody watching or listening, so there.
See that? See, any other time, I'm the first one running out.
Yeah.
Get to the restroom. Oh, I did that. Yeah, the new lady comes Monday, doesn't she?
Ma'am?
Then the new lady come Monday.
Yes, ma'am.
And I meant to ask Mr. because the thing said as far as Brandon moving, how all three of you gonna be in there?
Well, you know Heather's not there,
That's right.
so,
Yeah, we get that.
we'll manage, you know, because I wanted her to come in and, make sure she just read over some stuff, especially at the charter, see how y'all are set up, and, go from there. Like personnel policy, I know Jennifer will probably get with it. But it's just to get her familiarized with the department heads and who they are and what they do.
14 years here in Upson County. 10 to 12. 12 years in College Park. And the worst part, I don't care what here or in College Park, the worst part of this job to me was the minutes. Yeah, that was the worst part of this job, the minutes. And like I said, we had a court report in College Park, maybe 6 years before I retired or whatever. So that did help a lot. But these minutes is the one that's so difficult. And then do you go and take everything that's said pretty much, or do you just take your emotions and that kind of thing? That's always been.
Yeah, because I think you can just do what the action
Actions,
minutes
right.
and just take that, because you just, you know, I know when I first started doing the minutes, it was like I was afraid I wasn't going to get every word in there.
Right.
But then I realized when you don't have to do that.
No, you
Because
don't.
I had to be self-taught. Because nobody really told me, and I looked back in the minutes, previous minutes, when I first came. Because there was times when I had to fill in for Phil,
Right.
and then when he was out sick, fill in, and then I had the minutes from Planning Commission, Zoning Commission, the Board of Zoning Appeals, Tree Board at one time, but then they, within the board, they got their own secretary, so.
But yeah, that was the worst part of a city clerk's job to me, was the minutes. I could deal with any and everything else, but the minutes. That's what would take a lot of your time too.
It does. And then up there in my office is so distraction, because people coming in and out and all, and you're trying to listen and make sure you want the motion that you was done, you want that correct.
Right.
So,
I don't miss it one bit. I don't. I really don't. Like I said, the worst part was the minutes of all of them. Yes, but because this councilman wants this, what they said here, they want that in the minutes, and this councilman wants that in the minutes.
yeah.
Yeah, College Park, it was something else.
Yeah, I'm glad you mentioned the court recorder, because I was concerned about even sitting in on any of those hearings, because that's, that could be rough on the city for it if you don't record it
Right.
accordingly, and I think the court recorder should do that. Because that's basically setting it up as a court hearing.
I was so glad when that came about. Geez, she's just a part-time employee or.
Well,
like that.
see, Lonnie has mentioned that before.
About a court report.
Cause he goes, you know, he does work for Lovejoy, and that's what they have.
Okay.
And, but, just never have been brought up or, you know, or considered. The same way with the elections, you know. The, election board's doing the elections, but you still gotta have somebody with the city
City, right.
qualified.
In College Park, I was the election superintendent. I handled the elections. Because College Park didn't want Fulton County doing none of its work. Didn't want this College Park build its own taxes and all such as that. On business license, they didn't want Fulton County doing anything for them. Yes, buddy. So yeah, I went through all of that with the election. When I first went there, we were doing paper ballots. But that very first year, it was such a mess till we went to the machines, the direct recording machines. The city bought its own machines and all such as that, and we did all right. Yep. they
Yeah,
want
I know.
Fulton County
I
doing
remember when the
anything.
city had just individuals that worked out of the registrar's office, but they
Okay.
did the city election.
Okay.
And all that was by hand.
Yes, but and this is the first time when I went to vote the last time, that's the first time I had gone to the actual polling site to vote. I had been doing absentee or whatever, so when I went to this time to the site, it was totally different.
Yes, it sure was.
Totally different. Yeah, I can see this thing kind of both ways. But yeah, 90 days is a long time. I can't believe, like I said, I can't believe the city hadn't been doing it all along.
Well, they may have had to deal with people, I can't remember that man's name. He lived over there on, Matthews Avenue. The house has been torn down. He was always doing something wrong. I remember something about his license.
Matthews, and he had a license, an alcohol license.
I'm trying to remember what he got in trouble for.
Matthews.
He probably was selling alcohol and he didn't have a license over there, you know, out his back door.
Okay.
But he's dead now.
Oh, is that? I don't know who
I
they could have
cannot
been.
remember. The house is torn down.
Yeah, I don't know who they could
He
have
had
been.
gotten in bad health. He was in a wheelchair. I want to say his last name was a Walker. but
I
I'm
know
not
who you're
sure.
talking about, JB.
Yeah.
Yeah, he died years ago. Yeah,
We
JB.
always had something.
Yeah, he was always in something. I remember.
Yeah.
Yeah, he had a little cafe too.
But as far as, I don't ever remember this coming up
Really?
because I just, you know, I'm sure they've gone in and cited people, but not sure what.
The process was. But anyway, like I said, this is a learning experience. We'll know. And then I hope the folks at the convenience stores and things will stop doing it.
Yeah,
Yeah, because if not, there's some working way out of business.
I know, pay more
Uh-huh.
attention.
If you catch them one time, believe it or not, they'll go back a second time and do it.
Yeah.
brought me something to eat.
Everybody here? All right. We'll come back into regular session from the recess we had. y'all found some answers maybe?
We did. We had to look at the charter as well as Robert's rules. Our charter refers us to Robert's rules, and it specifically says under Rule 17 that further government of the city council, the rules of parliamentary usage as laid down by Robert's Rules of Order in short edition shall be used, except when it's in conflict with any law, ordinance, resolution, or rule of the city. And Robert's rules specifically have a scenario: 2 votes yes, 1 vote no, and 2 abstentions. Says the measure passes because it was received as an affirmative vote of the quorum. So it would pass.
So it would pass. All right, Jill. Is there any other?
That's all I got, Mayor.
Well, but, so let me ask you, because of that it passes, and that makes sense. So it's gonna be heard in front of the city council. So if 2 of us are not here to conflict, does it in any way affect the hearing of it if 2 of the 5 are not here?
It's supposed to be mayor and city council that hears. So it's not, I mean,
Is that present and not vote, or is it, like Doug said, do we just excuse ourselves at the time of the hearing?
Because if we're present and we don't vote, we have to abstain, right?
right.
And so would the same rule apply according to Robert's Rules of Orders? That-
Yes, it
Okay.
would.
Mhm.
The mayor, and again, this is kind of forming as we go because there's no specifics. But my understanding is the mayor would act as presiding over, just like he does the regular meeting. And then,
3 votes.
You still have the majority of the council?
You would still have a majority of the council
Hmm.
with the 3, and then you 2 out. Unless anybody else had a conflict as well, with somebody.
Oh, well, that's it.
Is there anything else? If not, motion to adjourn?
So moved.
Second?
So before we break, I'm sorry, are we still looking at the 16th and the 23rd? I'm not sure. Okay.
What time?
10 o'clock.
Well, we got here at 7.
7, I think we said we was gonna do it early, wasn't it?
What time are we looking at?
10 o'clock. 8:30. So we got here at 7.
Well, I guess it kind of depends on that other person. So I guess we will be, we probably need to start as early as we can, but we need to accommodate the other attorney that's coming in probably too.
I think that would be
And
fine.
we doing 7 each day?
So an 8:30 meeting, is that,
I mean,
Kinda.
we're used to reporting to court at 9 o'clock, so, 8:30, 9 o'clock should be fine.
so 8:30, 9 o'clock, what'd y'all say?
8:30?
9 would be better for me.
9 better for him, so 9 a.m. both days.
All right.
All right. We have a motion to adjourn, have a second.
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 All in favor, say aye, go home.
All right.